Okay, so here's the case law framework. It's basically three big cases. So Marsh versus Scott, 1949 case. The court can permit the guardian to exercise all powers the ward could exercise if not disabled, including the power to transfer assets as gifts. And then in Trott is really the case that Keri relied on. And the Supreme Court adopted the Keri, the Henry Trott analysis, a way of analyzing whether the proposed transfers would be in the ward's best interest. Basically, they said if the Henry Trott involved estate planning issue and said that the incapacitated person shouldn't be denied the right to engage in estate planning since people who were competent were permitted to engage in estate planning, even though it would reduce the amount of taxes paid to the general public. There was nothing wrong with it. So here's the criteria for a guardian making gifts in that context of estate planning. The mental, physical condition of the incapacitated are such that the possibility of restoration capacity is non-existent. The assets are more than adequate to meet the ward's needs. So in other words, there has to be sufficient assets remaining in the ward's estate or in the ward's name to pay for whatever care is necessary for the ward. The donees are not natural objects of the ward's bounty. If they have a will, it's very easy to identify those. Without a will, you have to go by the intestacy statute. The transfer will benefit the ward's estate. It's pretty straightforward to prove it, since if you don't make transfers of assets, all the money is going to go towards payment of the facility care. And if it does, the person's loved ones are going to benefit. And the Supreme Court just presumed that, people would rather have their loved ones benefit than a nursing home or an assisted living facility. And then there can't be any evidence that the incapacitated person would not have made the gifts if they were competent. I've never seen that come up, but could be a situation, I guess. Okay. Keri adopted that Trott framework and said, so long as the law allows competent people to engage in Medicaid planning, and it did at that time too, incompetent persons should be able to do so. They should have the same right as competent people do. And that's how he overcame the issue that we were running into, the problems we were running into with judges. Okay, so a lot of these forms are, Constantina did a great job presenting at all the different kind of forms that you needed. And I'll go through them, but I'm just going to point out the things that are different with Medicaid planning. Okay, so I think Constantina covered this, and there's no issue that's different in these initial forms as certification of assets. This one was the order fixing the guardianship hearing with blanks for the court to submit, to fill out, And then the certification of assets, just listing all of the assets owned by the incapacitated person. Of course, the two doctor certifications giving their opinion as to the competency of the individual. The case information statement, relatively new, but that also has to be submitted. The proposed judgment. And one thing that's different here, if you are asking the court to permit Medicaid planning, that is not provisions as to Medicaid planning are not included in the typical form that you have from the court. So that has to be included in there. Asking to transfer a house or to make gifts of some kind, you have to make sure that's included in the judgment. And then a brief. I mean, I usually do not, prepare a brief if it's just a straightforward guardianship. But if you're going to ask for Medicaid planning, it's usually a good idea because you want to educate the judge on the grounds for making this request, addressing the guardian's legal right to conduct Medicaid planning, and showing the Trott factors so that there's no question that you can do what you want to do and you've met the legal requirements. So here are the basic requirements for the verified complaint. Constantina covered those. The name and address of the institution, the period of time the alleged incapacitated lived there, name and address of power of attorney. I always attach the doctor's certifications, the estate documents if the incapacitated has them, will, power of attorney, things like that. And for Medicaid planning, I usually give a presentation of how much the income that the individual has, the amount that they're going to need every month in addition to their income to pay for the cost, the impact that the transfers would have on the person's Medicaid eligibility, i.e., would they be ineligible for a certain period of time, and have I allowed enough money for the person to pay privately for that period. And I try to prove that if the person was competent, that they would take these steps to accelerate their Medicaid eligibility to preserve assets for their loved ones. It's not really a question that I've seen raised by courts if there's a spouse or adult children involved, as there usually are. The judge usually adopts the situation and accepts the fact that the individual would rather the loved ones get the assets of the incapacitated person rather than any care facility. And I usually point out the federal and state protections showing that the individual is not going to receive inferior care or less care because they're on Medicaid status. So their quality of life is not going to be impacted by the proposed transfers. Okay, so also, you always have to address the Trott factors because that's how the judges are making decisions on whether to allow you to do the plan. Is there any chance of restoring capacity, competency? Not usually. Are the assets you're retaining sufficient to meet the financial needs of the incapacitated and pay for all of their care needs? It's gotta do that, and it's good to, just lay it all out for the court. What is the plan? Show that the donees are the natural objects of the incapacited's bounty, which is relatively, it's straightforward. If you have a will, usually the transfers are being made to the people that are mentioned in the will. Or if we're transferring to a trust, you replicate the distribution pattern in the trust that was set out in the will. And if you do that, the judges typically will recognize that as having met that requirement. The transfer will benefit the estate. It's usually assumed, as I said, that the loved ones, the judges the incapacitated would rather the loved ones receive the assets. And then I've not had a case where there was any evidence that the alleged incapacitated would not make the gifts. but that is an issue that you have to address. Okay, this is important. You know, you want to, if you can show, if the people to whom the assets are being transferred are the same people that are named in the will, there's no problem, because, you know, the incapacitated person, when they were competent, chose those people as people they wanted to benefit. And if no will, are the people who would take through intestacy the same people that are going to receive the assets that you transfer.